Okay, this week we're revisiting the exam. You'll recall that just before or in the mid-semester break, I prepared an initial exam, a preliminary examination preparation session. The intention of this session is to develop and just take a step further in terms of the exam, particularly now that we've worked our way through the material relevant to the examination in terms of the course. So for each week, we've of course had a number of pieces of information, and that information is obviously all on Moodle. We've got some written text, we've got a video done in the past as to the course, we've got the recording that I've done each week as to the tutorials, and so there's a range of pieces of information there relevant to you. You know the structure of the exam, that is that it's two parts, Part A and Part B. Part A is 20 marks, and you have to answer 4 out of 6 questions. In Part A and or Part B, there are no multiple choice questions. You will have seen a couple of times mentioned in the past, this course in Part A had multiple choice. This exam, the exam you're doing, is different. There are no multiple choice questions, so you can be certain about that. So let's talk further about Part A. Question 1 in Part A is about agency. So you need to understand and be very clear about the different ways that an agency relationship can be created. Remember, agency is a contractual relationship between a principal and an agent. And how do you define the boundaries of that agency relationship? Often the agency might be expressed in a written form, but maybe you might arm someone. That is, for example, you might give someone a uniform, and the uniform might refer to your organisation, and that might arm that person with effectively an agency. And you might recall that that's called an ostensible authority or an ostensible agency. So this question 1 in Part A refers to these concepts of agency, and you need to be able to differentiate the express creation of an agency and the implied creation of an agency, and you need to be able to give examples of those two things. Question 2. It's about the Competition and Consumer Act, and you will recall that at the end of the Competition and Consumer Act, which is a Commonwealth Act, there is a schedule, and in that schedule is called the Australian Consumer Law. And in that schedule there are some key provisions which were copied or taken across from what used to be called the Trade Practices Act. And a key part of the Trade Practices Act was this idea of misleading and deceptive conduct. And this question is fundamentally about that concept. And you need to understand the Australian Consumer Law, how it fits into place in terms of the Competition and Consumer Act, and how that particular part of the Australian Consumer Law might be applied. Question 3. This question's about the terms of contracts. So you need to understand the way terms are incorporated into an agreement which forms the basis for a contract, and the different types of terms. Remember, there are more important terms which are conditions and less important terms which are warranties, and there are ones which are sort of in between the important and the less important ones, innominate or intermediate terms. And how are those terms included in contracts? Are they included expressly or by implication, etc.? Question 4. This question is about intellectual property, and of course there are a number of intellectual property statutes in Australia. The Designs Act is the newest, the Patents Act, copyrights and trademarks. You need to understand what each of those does and know that they are Commonwealth pieces of legislation and that each of them has a different role to play in intellectual property in Australia. Question 5, it's about the difference between, in property law, between different types of property ownership, if we call it that. Of course, there are fixtures, there are chattels, there are a range of things, but there are also, how do you hold a property? Do you hold it as a joint tenant or a tenant in common? So there are a range of things that might be relevant to you in this question that you need to examine. Question 6. This is about the concepts of bankruptcy and the things we looked at in that module. And how does a person become a bankrupt? Remember, there are debtors' petitions and creditors' petitions. So if you think about Part A, questions 1 to 6, as we've just discussed, this is very much like an assignment type scenario. That is, you go away and you research and prepare information about each of these specific topics, and you go into the exam and you there's no surprises here. It's not like any of these questions are going to be outside of the realm of the stuff that you will research. It's very much an opportunity for you to prepare and then go into the exam and articulate the research that you've already done on each of these specific topics. Remember, you only need to pick 4 out of those 6 and write about each. To give you an idea, the first question is 3 lines long, the second is 5 lines, the third is 2, the fourth is 2, the fifth is 2, and the sixth is 2. So none of them are very long questions either. So it's not a problem in terms of something hidden or something you won't be able to see. It's very much about you preparing and going into the exam with quality of preparation and articulating that preparation on the exam script. Part B. So this is the guts of the exam, if you like. It's 40 marks and you have to answer all 4 questions. So these, of course, are a little bit harder, and they're asking you to pick up specific concepts. These are what we call problem questions, and each of the 4 of them requires you will remember, requires you to articulate what is the question that I'm being asked, what is the issue that is applicable to that question, the legal issue, what are the facts relevant to that legal issue, what's the law applicable to that legal issue, how do I apply that law to the facts, application. I need to come to some conclusion about the legal issue, and I need to answer the question. Question, issue, facts, law, application, conclusion, answer. So you need to be structured in the way you approach it. You need to put as much relevant legal information as you can into your answer. Your answers should be clear, they should be legible, they should be on one question on 1 page or 2 pages or 3 pages. Finish that question, then move on to the next question on another page. Each page should have a clear identification at the top of the page of the question that's being answered. There should be no uncertainty about what question you're answering on what page. All right, so the first question. This is a question of agency. It involves 2 human beings, and the issue is whether the agent is acting within the scope of his authority. And so it's an actual authority question in the sense that the agent has been told some specific information, and the question then is whether the agent has acted in accordance with that specific information. This question's 5 lines long, and it's obviously agency is the issue, And so you need to examine the agency relationship between the two individuals having regard to the facts in question. The second question. Now, this is about a company that imports stuff into Australia, and it enters into a contractual relationship with another company. And it says, we will do something by a certain date. Now, the problem for the importing company is that, of course, they're reliant on the international trade to provide their goods to the other company to whom they've contracted. And there's an additional problem whereby, of course, there might be a problem as to the goods that do arrive. So they might arrive late, but they also might have a problem with them. So the question then is, if there are goods that arrive late, and if there's some problem with the goods, what is the course of action that can be adopted? Is there a right to sue, and will they be successful, and what are the remedies that might result from that circumstance? So that's something you'll need to consider. But of course, think about the Australian consumer law, think about terms of the contract, think about the Sale of Goods Act, think about misrepresentation, negligent misrepresentation in tort. So there's about 4 possible causes of action and remedies that might be available to a party in those circumstances. Question 3. This is about an individual person who wants to buy a bicycle. And the question then is, if she's buying a bicycle, she then has a specific use for the bicycle, and she articulates to the what she wants to buy the bike for. The bicycle shop identifies a specific bicycle in those circumstances. And the question then becomes, well, if the bike is or isn't suitable for the use to which she articulates, is there a cause of action against the bicycle shop in those circumstances? And you have to advise the individual who purchases the bicycle. So once again, think about negligent misrepresentation, think about the Sale of Goods Act, think about the contractual terms, think about the Australian consumer law, and apply those things to the facts. So this question at first blush sounds familiar to the other question. In fact, you'll see question 4, that this sounds like there's some familiarity between these questions. There is, in the sense that we're talking about commercial law as a whole, and we're trying to apply a range of possible remedies. And the remedies are basically remedies in tort, like negligence, remedies in contract, like breach of contract, obviously, and remedies in statute. And in fact, questions 2, 3, and 4, in a general sense, are looking at those broad brush issues, but of course they're looking at them in terms of different facts, different information, different intricacies. And what you'll find is that, of course, different parts of those of the course will be more in play in the different questions. Question 4, you have an individual again. They want to buy a computer, and they want to buy a computer with software, and they talk to a company about that purchase. And the question then is whether they can return the computer. So there are some slightly different issues in this question, and you once again have to advise the individual who purchases the computer and the software. So you'll see that part B, I should say, is very different to part A. They are problem questions. They require you to identify specific issues based upon factual information. In part B, question 1 is 5 lines. Question 2 is 12 lines long. Question 3 17 lines long. Question 4 is 13 lines long approximately. So each of the 4 questions in part B is worth 10 marks. The intention for next week is to look at some practice questions that will be similar and relevant in terms of these questions, particularly the part B questions. The exam is obviously constructed so that you can, if you prepare well, do very well on part A. And of course, if you prepare generally and do practice questions, you'll do very well on part B. But obviously the part B questions are harder than the part A questions. But through the combination of this recording and the earlier recording from earlier in the semester, you should have a very good heads up of where you're heading in terms of your preparation for the exam.